and I would be happy to take up any questions if you have.
Thank you, sir, for the nice lecture on bioresources and their protection through the mechanism of IP, both under the Biodiversity Act and also through the traditional knowledge defensive mechanism that is available to us. Sir, we have one question in the chat box from Mr. Alaka Samal as to how to protect traditional knowledge of our country in absence of legal provision. So, is there any legal provision, and how long we try to take shelter under other IP laws for protecting traditional knowledge?
See,
Yes.
we have to not focus on the traditional knowledge from the legal isolation point of view. We cannot see it from a secluded mechanism. The moment we talk about traditional knowledge, we do know that it has something from the biological resources perspective I'm referring to. We definitely have to look into from the perspective of intellectual property right, from Biological Diversity Act, from the geographical indications regulations that we have. Now, the point of discussion here is we have something called Section 7 to the Biological Diversity Act, because we cannot seclude the access to the biological resources merely because we want to protect it. Now, the moment we talk about seclusion of access, that means we're trying to regulate the access of any person to those biological resources. Otherwise, anyone can go and have an access and anyone can exploit. I'll give you an example of it. You must have heard about the issue of Kani tribe in the Kerala, where few explorers, they came to Kerala, they went to this tribe called Kani, they wanted to explore the nature, they were exploring something else, but they could see that the people who are their guide, who are the local inhabitants, they were not getting like stressed out, they were not getting the fatigue after so much of work. The moment they asked them, how are you not getting tired? The answer was, we eat this particular leaf, and this leaf gives us enough energy to sustain for quite some time. They took some samples of those leaves. They extracted a specific compound out of it, and they said this is what is the basic requirement for giving you a longer stamina with respect to walking and exercising and doing your daily core. Now, that is something which was embedded as a traditional knowledge with those tribes. But some people went there and got an access to it and make it a brand and commercialized it in the market, and they started selling it. Does this mean that the traditional knowledge has now no more a traditional knowledge because it has got exploited? Yes, it has, because that traditional knowledge belonged to those people, the Kani tribe. So the matter went on to a discourse of whether they can have a patent over it. The answer was no, because it is a matter of their traditional time. They can share the benefits with the people. They can have a collaborative interest in it. Then we went to the access and benefit sharing properties. Then once the access and benefit sharing property went on, then they went on for sharing. The company shared some benefits with them. And so does the Divya Pharma case, what we refer to. The benefits ultimately accrue to the people who are the beholders of the traditional knowledge. But the moment I am referring to Section 7, Section 7 gives some levity to Baids and Hakims, who are the practitioners of traditional knowledge with respect to biological resources. Now, these are some of the factors that we have to deal with respect to the protection of traditional knowledge. We cannot exclusively look forward to protection of one traditional knowledge through an inclusion of something in isolation, but you have to look it with the harmony, not in isolation.
By Mr. Paneer Selvam, how far there is a connection between Biodiversity Act and the Rio de Janeiro 1992?
Yes, I got the point. Now, the moment we are talking about biodiversity, the Rio Declaration of 1992 that we are talking about here, that is a comprehensive mechanism of environment. But out of the environment, if you see, after 1992, when we got that factor, which is the development of 1972, the Stockholm Conference. Now, that development have seen, because we thought that 72 culminations have not been effectuated properly. So we wanted to protect the whole set of environment through structural approach by giving more responsibility to the state. But when we come to the point of discussion here, because that is on a wider ambit of environment, but we are talking about a fragmented portion of the environment, that is the biological resources. I'll tell you, sir. In 1986, we came up with the Environment Protection Act, EPA, wherein we tried to give a constructive definition to the environment. Environment includes, which said air, water, land, the interrelationship between air, water, land amongst and within themselves, and which also includes forest, biodiversity, microorganisms, living organisms, and all such things. Now, the point here is, the moment we are talking about one of the components of the environment needs to be protected because it has a commercial value, and the people are now exploiting or exploring it in means of bioprospecting or biopiracy, that means the ultimate objective that we are looking forward to protect is the environment. Because every component of the environment is a biological resource. And when we are talking about the biological resource and it is prospectized or it is exploited, ultimately it means that the benefits are going to be derived. And the moment we are deriving benefits, and that's what I always say, we're looking for development, economic development. But in environmental terms, if you can directly point out 1992, it has been discussed that environment is indirectly proportional to development. The more the development would happen, the more environmental pollution would happen. So every time we compare that, we have to bring in a balance between both the two. And that is where the whole CBD and 1992, the Earth Summit, comes in perimeteria with each other for bringing those balance.
The relationship between the CBD Act and the Plant Varieties Protection Act, and also some recent case laws regarding the traditional knowledge.
Yeah. So after I'll just answer the second portion, then we'll come to the PPVFR Act. Okay. Now, there are, after the TKDL has come into place, the Traditional Knowledge Digital Library, we have seen various cases like the Ginger case, which have seen the Multani Mittis case, which has come also into the limelight. The calamine lotion issue have come up into the limelight. The ingredients in Javed Habib's case, the wheat case, these are some of the factors which you can definitely take into consideration. But talking about the relationship between the CBD and the PPVFR, the Plant Variety Protection Act, it has a cross-sectional point of that the plant varieties. The CBD is talking about protection of biological resources per se. The patent regulations are talking about extractions of any component of it, and then inventions upon it can be made as a part, as a factor of protection. And on the contrary, the PPVFR Act talks about protecting the interest of the farmers with respect to the plant origins, the plant varieties. Now, you'd happily understand this fact when you are associating with the local or sui generis system that we have. That is, let's say, the Seeds Act. Now, why do we have the Seeds Act? Because seeds are also getting harmonized. I'm taking a seed from the nature. I'm exploiting the seed on terms of in my laboratory. I'm getting a hybridized seed. Then I'm getting a patent over it. Now, the point of discussion here is, in true sense of biological resource and the protection of the biological resource, I cannot get any exclusivity of my interest over the life and the life form that is naturally available. But on the contrary, I can do that in a controlled environment. I can come up with a new invention, but I can get it protected in a subsequent environment and in the subsequent atmosphere through other legislative framework that I have, just in the nature of PPVFR.
Next question, sir, from one Mr. Mohan Rao Hanchate. This is respect to, it's like how IPR protection is contributing to environmental degradation. Like, are we giving a green signal, a go ahead to exploit the resources without any restrictions and limitations?
No, that's not the thing. I'll just give you an example of it. Few years back, I guess 3 years back, I met this person, because we are talking now about the ABS mechanism more, that we under environmental law had this principle called polluter pays principle, But for some time, it has become pay and pollute principle at the present point in time. But when we include the whole point of IPR protection to this, we are trying to give a controlled access to the biological resources so that two things will happen. First, there is no exploitation of the resource. And if there is no exploitation of the resource, the second aspect will be environmental sustenance, which are the two aspects which is coming out of even some other person had asked of the 1992 phenomenon, the Rio Declaration. The sustainability yardsticks also have come from there as a matter of discussions out here. Now, I'll give you an example which I got to know 3 years back when I met a person. He said, I asked him, sir, what do you do? He said, sir, I am manufacturing handmade papers. I said, sir, how are you manufacturing handmade papers? He said, sir, I'm manufacturing handmade papers from a particular grass which is grown specifically in that particular region of Gujarat. I said, oh, then it's a local knowledge, I believe. Now, yes, it's a local knowledge, but I'm involving some machineries which I have procured from China, and I have kept it in my ashram because he's a mahant, and I'm manufacturing this thing for the market. I'm selling it in the market. I said, sir, are you getting benefits out of it? He said, yes, because I'm selling it in the market. The moment I said, sir, the moment you are selling it in the market, that means you are commercially exploiting that particular resource, which ultimately is controlled under the Biological Diversity Act and the rules thereof. What does it mean? It means that you can access that resource only when you ask for a permission. The moment you get a permission, you have to comply with certain forms which is being given there under the rules, biological diversity rules. And subsequent to that, if you're deriving any commercial benefit out of it, then for the usage of that particular resource, you have to give a benefit back to, a share of your benefit back to the people of that particular local community, which is the ultimate forum of the access and benefit sharing. Are you giving anything of that sort? He said, no. Have you asked for any permission? He said, no. Then I said, you are doing nothing but polluting the environment and the resource without due approval from the institutional mechanism which has been created by the CBD, Conventional of Biodiversity, and the Biodiversity Act in India, and for which you can be made liable subsequently. And God forbid, that point in time, he was saying the same thing to me in front of the chairperson of the GPCB, Gujarat Pollution Control Board. And I said, sir, you have a valid case right now, you can charge him fine. It just ended up with a smile, but ultimately they can do so. That is what the framework of law does suggest.
We have one more question from Ms. Samina. It is regarding how we can stop the exploitation by foreign countries of the ancient knowledge of India, like you referred in the Colgate case.
Yes.
And how we can fight for our rights.
Okay. So I'll tell you the process of patent when it is filed. The one step is in between before the grant of patent is that public notice, when it is given to the public for raising any show cause, giving any responses or giving any feedbacks. Okay. The moment we talk about the biological resources, a complicit factor here for the protection is its identification, its knowledge. We don't even know how many biological resources we hold in our nature. India is a biologically diverse country. We don't have any explicit knowledge about it. The moment we do know about it, and the moment any person files for having a patent over it, then we can certainly give a response to it. No, it is not possible because we already have this as a knowledge. And that is the whole reason for which we have come up with the Traditional Knowledge Digital Library, TKDL. It's an open website wherein all the details have been placed. The known knowledge has been placed, but there would be a lot of things which is not even known. Therefore, we need to see that all these things are documented, and for which the CBD, the Biological Diversity Act 2002 is very rigorously working towards bringing those PBRs, biological registers, so that a comprehensive documentation of these biological resources are being get known to the people.
Sir, we have one more question from Mr. Pankaj Kumar. What amendments were made in the Trademark and GI Act in view of the traditional knowledge?
Yeah. So the moment we're talking about the amendments, the first amendment what happened in the TKDL when we talk about the inclusions of having a composite interface. The moment we talk about the GI Act, the GI Act got amended in the year 2003, where it is collective rights was one of the factors which was brought under the domain of the TRIPS and WTO, which talks about GI registrations with respect to the collective rights. The collective rights, when we talk about, it acknowledges that the community people who are holding the interest within the biological resources, they own the resources. And in India, the GI Act was to give them the protection thereof. And this is the whole factor that got amended. And I guess he asked for the Patents Act. I guess Patents Act I have already answered to the Patents Act. But I'll mention one more thing. It has also got an amendment done to the PPVFR Act, the Protection of Plant Varieties and Farmers' Rights Act, wherein the PPVFR Act, wherein it was made provisions for benefit sharing and compensation for traditional and rural or tribal communities people whose knowledge is being regulated or culminated into a practice of getting protections. And it created nodal agencies, it provided for national gene fund, it also provided for authority who had
we have two questions from our team here.
Of those people. So these are few amendments which were being made
first
that
I will take
can recall of.
There is another question that has come from the participants from Mr. Chandrasekhar Patnaik. Is there a common law or a clause which encompasses both biodiversity and GI tag?
Actually, the
Yes.
GI tag is some signaling which device that helps a producer to differentiate their products from the rest of the compounds that they are working on. I'll tell you something. Let's say Kashmiri Kesar is one of the facts. It has a GI tag to itself. Now, the moment we are using Kashmiri Kesar, now the products need a differentiation, because we say Kesar can be manufactured from Kashmir, from any other places of Afghanistan, or from any other places. The moment we locate it or isolate to a geographical boundary or to a geographical foundation, then we have to differentiate within themselves, because it has a reputation in itself, and the goodwill that roams around it, it has a reputation of it. But when we look at the biological diversity does not segregate in terms of a compounding element. Biological diversity takes it as a whole. But within the biological diversity, just like somebody was asking me about the environment under 92, then biological diversity as a further component, then GI comes as a subsequent component to it. But within the biological diversity, it gives us an umbrella protection, and GI gives us a specific protection to the biological resource in that ambit.
Can you please tell about the sui generis system and the in situ or the ex situ system for the CBD?
Okay, in situ and ex situ conservation paradigm.
Yes.
Okay.
Yes.
So the moment we talk about the Biodiversity Act, the in situ conservation is about the monitoring processes. Okay, how we are regulating it. Now we have decentralized the whole process of regulating the biodiversity within the component of the Biodiversity Act. Now, the in situ conservation of institutionalizing factors are, we'll have a central authority, we'll have the biodiversity management committees, we'll have the mechanism of biodiversity registers through which we will be providing and monitoring the implementation of the same. The ex situ conservations are the effects of other legislative framework on the biodiversity, just like the Patents Act, just like the GI Act, just like the Environment Protection Act, or just like any other law. These are the laws or regulating factors with respect to access to the biological resources beyond that. I'll give you a small example of it. Suppose I want to have an access to a particular plant in a particular area. The in situ conservation says, how can I access it? The ex situ conservation would come when I would say this particular plant or this particular variety is situated in a reserved area. Then the Wildlife Protection Act or the Indian Forest Act would come into picture. that whether, how, and in what context can I go there and have an access, because the moment I enter into a reserve area, I might be arrested. That's what the law is. The Executive Conservation says that beyond the prescriptions of the Biological Diversity Act, if there is any other context in which we are getting the permissions done.
We have a question from our teams here. The traditional knowledge, the TKDL register that is there, it is a defensive mechanism against those entries that are present in the register cannot be granted a patent. So whatever entries that are there in the TKDL register, they are positively available in the public domain for exploitation by all without any commercial angle to it. Whereas coming to the Biological Diversity Act and the bioregisters that are there, here the benefit, the ABS also is there, the access benefit sharing. It is between the actual persons who are exploiting the bioresources and the persons who are actually in charge or who are there situated near the bioresources. So with which protection according to you is more beneficial or better, or can you please elaborate on this?
The moment we talk about a sui generis mechanism, just like a TKDL, we have come up as a defensive mechanism, just like Irfan sir said, that it tries to give us the first layer of protection. But on the contrary, the first layer of protection is not a vital one. We may not know how far it is going to get implemented, how far it is going to get affected, till the time it comes to the limelight, till the time it comes to the knowledge of the people. Just like I was telling you about the Jeevani incident of the Kani tribe. A tribal person, what opportunity does the person holds with respect to know of the fact that something which he has said to somebody in good faith has actually hit the market as a product? Now, the moment I get to know of this, then what thing can I do? They are multinational companies. They can definitely exploit my resources, and I cannot be in any way be of any use to them to get them back to justice. But it is a mechanism through which the state has come up with regard to protecting the same. What they have done, they have come up with the Biodiversity Act, they have come up with the rules. With the rules, they are saying that, no, we have to decentralize it. Why do we need to decentralize it? Because of two things. Because I'm sitting at a city, may not be knowing what is the traditional knowledge in a village, which are very embedded to their bloods and veins, or which are the resources that they do have. They must be knowing, I may not be knowing. So they are the person who knows what are the biological resources that is available with them. That is first. The second, the moment somebody comes to the exploitation or comes to the access of that thing or those resources, they would be the persons who can have the first instance or first encounter. So they should be given some responsibility in terms of managing the resources. This decentralization process has actually resulted in the constitution of the BMCs, Biodiversity Management Committees. And these committees not only records the bioresources which is available with them, but also with respect to the usage of them by the others. So they can also ask them any amount of money for access as a benefit sharing. They can also ask for any money for the access. They can deal with it, but it is subject to verification State Biodiversity Authority. I hope that creates a sound answer. The decentralization is the answer, because we have huge amount of resources at our disposal that we cannot succinctly document it and control it. I'll give you one example, Irfan sir, with respect to this thing.
Yes, sir.
I was having a meeting with the GPCB, Gujarat Pollution Control Board chairperson. I asked, sir, there are a lot of issues with respect to bioresource exploitations and so on and so forth. So why have you not been doing anything? He said, we are 4 people in one office, including me, and we have a whole state of Gujarat to manage. And this is a state with a huge amount of industrial applications happening. Then how would you do that? These are some of the practical issues that the officers do face. But decentralization can answer to many of these queries and questions.
So, in your opinion, rather than going for the complete public domain approach, in the traditional knowledge, by way of traditional knowledge, but the benefit sharing approach as under the ABS is better suited in order to bring into limelight, or in order to bring to the fore the actual hidden resources that are there, and which remain to be exploited.
It's like a double-edged sword, I would rather say, because the moment some hidden treasures comes out, there would be effectuate multiple market players which would also come into as vultures to exploit it. But definitely state intervention is required, because the local people are very susceptible, vulnerable to alluring offers, and they can be exploited at any means. You go to any tribal place and you just give them some 1,000 rupees and they would be giving all the resources to you. That's how India is. That's what the true India we live in. But at the same time, this decentralization with benefit sharing plus effective monitoring of the state is what I am meaning to implore.
Yes, sir. Yes, sir. Even just stating our problem or the disease which we are suffering may actually ignite them to disclose everything, even without any offer for money. Also, that's
Right.
how it is. There is one last follow-up question. It is from Mr. Chandrasekhar Patnaik. Uh, do you mean to say, sir? Do you mean to say that the traditional knowledge of plant extraction cannot be legalized? That is, with respect to the process of extraction, whether that process can be legalized, or whether only the ultimate product can be legalized.
See, the patent regulation says it can be the process also, but the only
Yes.
caveat is the singular forms of microorganisms cannot be, and anything which is found in the nature in its true sense cannot be. These are the true caveat through which the whole patent regulations is competing as of now with respect to the Biological Diversity Act. But if you come up with any inventions of involving a process through the inventive step or in the way of inventive step, the process can also be patented.
Last question from Mr. Pankaj Kumar. He says that whether TKDL is safe as shared with the patent officers internationally, but not with US.
USPTO.
Yes, sir.
Okay.
Yes, sir. So this is what you were trying to deliberate earlier.
Yes. I was just trying to say this USPTO has the same thing as compared to the TKDL, but the thing is, you need some knowledge just to counter that if any knowledge is getting patented or not. And to get that, at least this is one step in the beginning towards the humongous task that we have. I was just referring to the same situation. Just imagine, with a huge biological resource country, surplus country that India is, without even knowing of the fact, we are more intent to get trapped into the dumbness of knowledge. We don't have that knowledge of multiple things. And for that reason, if somebody gets the benefit, can we go tomorrow and say, no, you cannot do that? We definitely can counter them, but we have to establish it. But in the process of getting those benefits, if we very first in this first instance itself, we put a caveat, we put a barrier, that itself is sufficient enough to get our concerns visualized. That was what I was intending to say. At least
Yes,
it's
sir.
something better than having nothing.
Thank you very much, Dr. Bishwa Kallyan Dash. Sir, thank you for patiently answering all the queries.